So, Your Honor, we are now on.
Can I just make a statement at the outset?
Sure.
And I'm embarrassed to have to say this to you all, but I just recalled, I did not recall at the time, but Alan Bozer, who played Al Capone, and I used to be law partners. I had forgotten that, so I probably should have recused myself from the trial.
Would that have affected your ruling?
No, not at all.
Appeal. So, you're right. Just there's a way of background. Were you destined to be a lawyer? Was this something in your family?
My mom, who, God rest her soul, passed away in January at age 96, was a state Supreme Court reporter. And for those students who may not understand what a court reporter does, they are the person who sits in the courtroom and on their little machine they make a transcript of every word that is said during a trial. And when I was in high school, sometimes I would sit with her at night and help her proofread her transcripts. I would read from the transcript and she would read from her court reporter's notes to make sure that it was accurate. And in that way, I got interested in the law. And Trini, is she gone now? I feel a lot better if she, but she said that her family has a very technical background. I was a political science major. That's as close as I came to science. So, but I think my mom deserves a lot of credit for my interest in the law.
So, you went to a place called Notre Dame.
Yes.
So, you're one of those domers?
Yes, I did. Point of correction, Scott, I was at Notre Dame undergrad and then I went to Cornell Law School. But I did have Professor Blakey, who authored the RICO statute. He did, my first year at Cornell, he was a professor there, so I had criminal procedure from him.
And then you get done with Notre Dame. Was there something in Notre Dame that was an aha moment where you'd say, I want to be a lawyer?
It's interesting. I thought I wanted to be a lawyer, but I wasn't 100% sure. I took the LSAT my senior year at Notre Dame, but I decided to take a year off. Now they'd call it a gap year, but I took a year off between college and law school, and I worked as a VISTA volunteer, which is, I guess, I don't know if they still have them, but it's like AmeriCorps. And I worked at a legal services office in Wausau, Wisconsin, which is above the Arctic Circle. And I worked and learned more about the law from them, although obviously I was not a lawyer at that time. And then I went to Cornell.
So you go to Cornell, and now you have a degree. You're sworn in. Did you know you were coming back to Buffalo?
Yes. Well, it's interesting. I met my wife in college. She's from Michigan. We were both Midwesterners. She went to St. Mary's right across the street from Notre Dame, and we both thought that we would be interested in going to Chicago. So I did actually most of my interviewing at law firms in Chicago. But at the last minute, I decided maybe Chicago's a little bit too big, and decided to come back home to Buffalo. Never regret that I did that, although Chicago is a great city.
So you're thinking Buffalo, coming back home. As you're just going through the process, as many people have all done this, and looking for firms to possibly engage your services, what was the process?
I had interviewed at a couple of Buffalo firms, although, as I said, I did a lot of my interviewing with Chicago firms. But I did interview the Thanksgiving of my senior year, my last year in law school. I interviewed at the Moot Sprague firm in Buffalo and was hired there. Dick Griffin, many of you know, who passed away last fall, he was my mentor, and he continued to be my mentor from the time he hired me in 1978 up until his passing last year. I've always considered him to be my legal mentor. And I had the office right next to him, and early in my career I second chaired a couple of trials with him and developed some experience.
When you worked at Moot Sprague, you were your natural ilk to be a litigator?
Yeah, I think I always wanted to do litigation. And that's not to downplay any other area of law. Interestingly, my third year in law school, I took a tax course, and I got an A in it, which was one of my few A's. And to this day, I don't understand how that happened. But I always liked the idea of litigating and being up in a courtroom, and so that was my leaning.
So at some point, Moot Sprague becomes part of Phillips Lytle.
Well, a portion of Moot Sprague did, as you know. The Moot Sprague actually dissolved in 1990 for reasons which I won't get into, other than, well, I guess the main reason was that one of our major clients went into receivership, and we decided we could not keep it together. So I knew some folks from Phillips Lytle that I had litigated against, and talked to them, and literally walked out the door at Moot Sprague one night, and the next morning I was at Phillips Lytle. So, and then I stayed there from 1990 until 2007, when I was appointed to this position.
During that time period, you were incredibly well known in the Erie Bar Association, not only for your legal expertise, but your ability to get behind a microphone and to be an MC extraordinaire. I mean, there's many stories here of you taking it up a notch. Was that natural that you would be such a comedic force in the Erie Bar?
Well, I don't know. I enjoy humor, sometimes successfully, sometimes not. Although one thing that has changed, I used to like to make fun of judges, and now I just think that's totally inappropriate.
All right, when you have judges' conferences now, and it's just judges, do they ask you to be sort of the Toastmaster?
Not yet. Not happening.
Not happening, or you haven't been asked yet?
Well, I haven't been asked, and if I were to be asked, I'd probably say no. But
sort of a Lyndon Johnson answer. Yeah,
right.
yeah. Got it. So, but as part of the 16 years you were at Phillips Lytle, as was I, we marveled at your litigation abilities, and one particular case drew sort of international attention, called the Backdraft case. You want to talk a little bit about that?
Sure.
Now, let's go to the beginning, because we have a lot of students here who might not know what that really is.
That's right. I got to keep people's age ranges in mind. The Backdraft was a movie about firefighters. It's really the greatest movie that was ever made. But it was released in 1990, I believe, 1990 or 1991. We ended up representing two Buffalo firefighters who had written a screenplay about firefighters, and they sent it out to Hollywood. One of the two plaintiffs, John Zoll, had a connection through his father of someone who worked at Creative Artist Agency, which was a talent agency in Hollywood that also happened to represent Ron Howard, who directed the movie Backdraft. Well, one way or the other, they submitted their screenplays, and they didn't hear much back. They heard from the agency that it had been received, but they didn't hear anything until then the movie came out. And as they were watching it, they realized that it seemed to them that a lot of portions of their screenplay had appeared in the movie. So they decided to sue Universal Studios and Imagine Films, which had produced the movie, for copyright infringement because they had copyrighted their screenplays. I didn't have the case originally. A friend of mine had the case, Dan Oliverio, who's now at Hodgson Russ. And then he decided to leave the practice of law for a while and go into business, so he asked me if I wanted to take it over. And I said sure, and I enlisted my partner Paul Zydok, who at the time was also the managing partner of Phillips Lytle. We took the case on, and it's got a long and torturous history. We took it on in 1994. The case ended up settling in 2001, but as a result of some, what I would say, shenanigans by the studios in refusing to comply with some of our requests for various types of information and court orders to produce that information, they ended up getting their answer stricken, which is a tough thing for any defendant to do, because what that means is you cannot contest the liability portion of the case. We ended up having a trial date set for October 1st of 2001. And as you all know, on September 11th, 2001, the tragedy at the World Trade Center occurred, and firefighters were coming from all over the country, including one of our guys, to go to New York and help out. And the whole world loved firefighters. That trial had been scheduled for since the year previous to start on October 1st. I don't know whether there was some whether that played some role in the studio's view of maybe not wanting to go to trial on this case, but in any event, it was settled. The terms of the settlement remain confidential to this day, but I think everybody was happy. That probably, in my legal career, was the case I will remember the most.
So, was there an order of preclusion so that they could not be precluded from putting in the answer?
Right,
Wow.
right. And that went up on appeal to the Second Circuit, and we went up and down a couple times actually, but then the case ended up being settled. So.
Now, I understand, this is just sidebar stuff between you and me, but one of your associates who was working on that case is in our audience here today, one Scott Soroka. Would he
Yeah,
make
Scott,
a difference?
you didn't have much to do with it, as I recall. I'll take all the credit. No, Scott, yeah, didn't we, I think we showed the movie to our summer associates once when we got popcorn, so you could, yeah. Yeah, Scott, you can take all the credit.
Well, he did to me. Elliot Ness, being the grandson, that's okay, but, working with Jerry McCarthy. So, with that, I mean, you have that moment, and ultimately the ink is signed. I mean, what's the visceral reaction you have, as far as just as an attorney? I mean, you're doing your job, you're representing a client, but it's now over. The ink is drying.
On that case?
Yeah.
Yeah, it was, in a lot of ways, and again, I would not have been the only attorney trying the case. Paul Zidek would have been trying it. We had kind of split up our division of labor. I was real interested in seeing how it would have come out at trial, but on the other hand, we were afraid that at the particular time we might do better than we should have done in terms of a verdict, and then it might have gone up on appeal again and might have been sent back down. So we were happy to settle the case, but I just felt vindicated to some extent that they couldn't violate a court order and pay no price for it.
So 16 years with Phillips Lytle, a prestigious. 17 years, a prestigious law firm, I understand. And
So I've been told.
Yeah. And Marty told me to mention that. Please bring it up. Then, at some point, did you get the itch to be a judge? What's that process?
Yeah, I had never said I've got to be a judge. I had kind of an interest in it. I was happy at Phillips Lytle with partners like you and even Ellen. But I enjoyed doing what I was doing, but I always thought if the opportunity presented itself, I might like to pursue it, not as an elected position, and students, state court judges by and large are elected and federal judges are appointed. Now, I'm a magistrate judge, so I don't have to go through Senate confirmation. I'm appointed by the district judges. But I enjoy analysis of legal issues. I enjoy writing, and I always thought that might match well with my skill set. So I applied actually a couple times and was lucky enough on the last go-around to be appointed.
So as you were leaving, Morgan Graham, our managing partner at the time, is quoted as saying, "He's got the cognitive skills, temperament, and thoughtfulness required of the bench. He will have the respect of the bench and bar because of who he is and what he's done."
And he read it just as I wrote it.
That was going to be my point. So you switch over and you become now a magistrate. You're a federal district court, and you go to someplace now called the Robert H. Jackson Courthouse. For those who may not know the difference between being a federal district court judge and then a federal district court magistrate.
Right. Federal district court judges, as I said, they're nominated by the U.S. Senator and the U.S. President. They have to be confirmed by the entire U.S. Senate, and they are appointed for a life term. And the reason for that is, or the theory behind it is that if they're appointed for a life term, they're not going to have to run for re-election. They're not going to be subject to any type of political or other pressure, and they can just try to decide cases the way the law requires them to be decided. As a magistrate judge, I tell people that I'm appointed for a life term if my life is 8 years. But I just finished, I finished my first 8-year term in 2015. Next February will be the end of my second term. And I've asked to be considered for reappointment, but next year I'll be 70. Now, on the state court side, judges have to step down at age 70, but federal judges can keep going. So I'm hoping to be reappointed for at least some period of time, but you never know.
You know, just for the benefit of, again, many there are, could you just kind of list us, if you could, who the current federal district court judges are that sit at the Robert H. Jackson Federal Courthouse?
I'm supposed to remember their names.
Anybody have their cell phone?
Well, we have, okay, the active district judges are Larry Villardo and John Sinatra. And Larry was appointed, I believe, about 6 years ago, and John was appointed 2 years ago. In addition to that, we have two senior district judges, Richard Arcara and Bill Scretny, and they are in their late 70s, I think, and they are still going strong. So they don't have to stay there, but they do, and honestly, if we did not have their services, we'd be in a world of hurt, because our caseload is pretty voluminous.
In the state court system, of which we have many practitioners, family court judge, there's a circuit court judge, county court judge. Often they are asked to take on different roles during the course of a year. Is that such the case with magistrate judges? Well, if there is a case or case capacity question, do you actually take the jurisdictional stuff that the federal district court judge?
Well, my caseload right now is about 50% civil cases and 50% criminal cases. Is Trini still here, or did she leave?
She had to leave.
She had to leave. Okay, then I can say a lot of stuff that I wouldn't have said. Well,
and I can't use these questions she sent me.
I would like to just focus, if I could, because the bulk of this program is directed to criminal law and the role of the prosecutor and so forth. What I would like to just explain, I think the lawyers know, but perhaps the students don't know, that as Trini talked about prosecution of cases and the role of investigating a criminal case and so forth, the role of the magistrate judge and the district judge, but magistrate judges handle the criminal case from the very beginning up until the time of trial. If it's a misdemeanor case, which is one which you can be sentenced for up to a year, we can try those cases as well. Very rarely happens. If it's a felony case, meaning that the potential penalty is for a year or longer, those are tried only to district judges. And I don't have the statistics, Scott, you may, but the vast majority of federal criminal cases are resolved prior to trial. And the role of the magistrate judge, they see us a lot more than they'll see the district judges, quite frankly, in most cases. And my involvement as a magistrate judge begins when the U.S. Attorney's Office sends over an application for a search warrant. And Trini talked about how things have changed from pulling out file cabinets of documents now to searching computers. They can't do any of that unless a magistrate judge concludes that the government has established probable cause to search a particular computer or house or apartment or person for that matter. And the reason for that is that we all have constitutional protection against unreasonable searches and seizures. So the government has to convince me that they have established probable cause when they seek a search warrant to believe that there's going to be evidence of a crime found in a particular location. And the mechanics of how that works is they'll send over an application to me. It's usually signed by an FBI agent or some other law enforcement officer, and it will lay out the facts of their investigation. And if they're asking, for example, to search an apartment, they will tell me why they think that evidence of drugs or child pornography or whatever, what have you, will be found in this particular location. Now, probable cause is very difficult to define. There's a whole lot of definitions of it, but basically what it means is that looking at the presentation, would somebody reasonably think that there is something to pursue there at that particular location? It's not, they don't have to show me beyond a reasonable doubt, which you would have to do if you're trying to convict somebody at trial. But it's a common sense approach to looking at something. And I insist, and all my colleagues insist, that there be some level of detail made in that presentation. And usually we'll have some back and forth. Their initial presentation, I'll say, you're looking for too much, or you're looking for X, Y, and Z drugs, but you've only shown me that there may be drug X. So I have to, I'm kind of the gatekeeper, and my colleagues are, that we have to make sure that a search isn't going to be allowed unless it's supported by probable cause. And on rare occasions, I will just say you've made a completely perfect presentation. Scott, I know if it were coming from you, that would be the case. But usually, and everybody's acting in good faith, but usually there's different ways of looking at these things. So what usually happens is we'll have some modification of the presentation, and until I'm satisfied that I can sign a search warrant. And on rare occasions, I have said, no, I won't sign this because you haven't shown me, made that showing. Usually I will. What happens from that point, and it used to be that they would come over in person with the agent, and they'd sit in my chambers, and an assistant U.S. attorney with them, and then I would swear that person in person. Raise your right hand, just like you do a trial witness. You solemnly swear that your testimony will be the truth. I say, you presented this affidavit to me that you're going to sign. Is that the truth to the best of your knowledge? They say, yes, it is. And then I would sign the affidavit under their signature, and then I would sign the search warrant. Now most of that, and it's partially a result of COVID, but also just of evolving technology, that's all done remotely now. They don't come over anymore. They'll email it to me. And when I'm satisfied with the back and forth, then I will swear the agent over the telephone, and then I will electronically sign the warrant, send it back to them. So they used to have to come out, because when I'm on criminal duty, every third month is my what's called my duty month. It's kind of like being a doctor on call. If a search warrant application or criminal complaint comes in at any time during that month, weekends, evenings, whatever, I'm responsible for it. Yesterday was the last day of my March criminal duty month, so I'm a happy camper today. But the agent used to have to come out to my house on the weekend and sign it, and now we can do it all remotely, so it's easier for them and easier for me. Now, once that process occurs, and say a person is then charged with a crime following the search warrant, they'll be brought back before me, and time won't allow me to describe everything that occurs, but down the road, the defendant may say, well, that search warrant was not supported by probable cause, or it was too broad, there was probable cause for X, Y, and Z, but you're also searching A, B, and C, and therefore the evidence should be suppressed. If I'm the one who signed the search warrant, I will say to them, If you want, you can have another judge make the determination of whether that warrant was supported by probable cause, because I know, I'd be honest, but I can appreciate how people might perceive that if I'm the one who signed the warrant, I'm not likely to be totally objective of whether there was or was not probable cause. So we give them the option to have somebody else look at that.
Then as it does proceed through the process, the evidence is then gathered perhaps, and then it comes time on a complaint filed and served on somebody that might be a misdemeanor. What happens then?
Well, or it can be a felony complaint that comes before me. And again, if it's a complaint, the government has to show me, again, just like they would with a search warrant, they have to show me that there's probable cause to believe that this person has committed a crime. If I'm satisfied that they have, I will sign the complaint, and then an arrest warrant is issued and they appear before me. At that time, it's called the initial appearance, or if it's on an indictment, which I'll talk about in a moment, that's an arraignment. But I remind the defendants of their constitutional rights, that they have the right to remain silent. They cannot be compelled to testify against themselves, but that if they do say anything, it can be used against them. I remind them that they have the right to be represented by an attorney at all stages of the proceeding, and that if they cannot afford an attorney, one will be appointed for them. Most of the defendants who appear before me request appointment of counsel, and this may be shocking to some of you, but lawyers are not cheap, and so for a lot of people it is not financially feasible to retain somebody to represent themselves. So I will question them briefly about their financial background, what they earn per month, if anything, what kind of property they have, and if I'm satisfied that they qualify for appointment of counsel, I'll appoint usually an attorney from our excellent public defender's office. Then the next stage of the proceeding is that in most cases, the government will move to detain the person in jail pending the trial. That's a very significant stage of any case, because at that stage, up until the time of trial, and in fact up until the government is able, if they are, to prove their case beyond a reasonable doubt, each defendant is legally presumed innocent of the charges. And if I detain that person and say, you got to wait in jail until the time of your trial, that can be a couple years. And that's, for anybody's life, that's a significant period of time. So we'll normally have what's called a detention hearing, at which I have to make a decision of whether I'm going to release that person pending trial or whether they're going to be held. And to assist me in making that determination, I get a detailed report from our pretrial services office, which tells me, usually the reports are anywhere from 5 to 10 pages long. They'll talk about the person's criminal history. Do they have a long rap sheet? You heard rap sheet in the trial. Or do they have no criminal history? What's their family relationship? Have they been working? Do they have any mental health problems? And based on all of that, and then I hear from the counsel for the government and counsel for the defendant. And I have to make a determination of whether there are conditions which will reasonably assure me that if the person's released, and it's only two factors I can consider, the big factors, if they're going to be released, are they going to be a danger to the community? Or are they going to be a risk of flight? In other words, can I be sure that they're going to come back for trial? Normally what I will do is set some conditions for their release. I may ask a family member to post bail so that if the person takes off, that family member loses the bail. And in my experience, no matter what kind of crime a person has been charged with, normally they won't want to stick mom and dad or aunt or uncle with the possibility of losing their house. So usually if bail like that is posted, or they sign what's called a signature bond promising to pay money, that goes a long way toward convincing me that I can release them. I may release them on an ankle monitor so that their whereabouts can be posted. There are some cases where the issue is so clear-cut in my mind that I conclude that there are no conditions that I can impose, and then they are detained. I'm very reluctant to do that, as is every judge, because I recognize that they're legally presumed innocent of the charges, but there are, one of the differences, Trini talked about differences between the time of Robert Jackson and now. One of the horrendous differences, I think, is the prevalence of child pornography, which is, it's rampant. The internet brings many blessings to society. It also brings many curses, and child pornography is one of the curses that it brings. And those people, in the case of child pornography, there is no doubt that a crime has been committed. The question is the defendant before me the person who is responsible for that crime? Has that person received child pornography, or has that person produced child pornography? And I have to legally presume that they are innocent of the charges, but I can also consider in a bail hearing the strength of the evidence against them. And quite often that evidence is pictures on a cell phone or on a computer, which are truly god-awful, and God forbid any of you ever have to see them. I normally just get a description of them, but and that's bad enough. But again, I have to keep in mind that I'm not deciding in general whether it's a crime. It clearly is a crime. I need to decide, is this person the one who is responsible for it or not, and can they be released on conditions until their guilt or innocence is determined? So,
you mentioned cell phone, and you dodged the question upstairs. They talked about cell phones and evidence and how to get access to it. And
yeah, those are interesting questions, and had I known you were going to ask that, I would have brought my law clerk along with me. There's a lot of interesting debate about to what extent can a person be required to, for example, use a thumbprint to release information on their cell phone, or to provide an access code. And I think, we're not being recorded
No,
here, are we? Good.
No, they're not. That's off. That's all off.
I mean, there's a lot of cases that say, although you cannot be compelled to testify against yourself, you can be compelled to provide physical evidence that will enable access. And obviously, if that particular situation were brought before me, I'd have to carefully consider it. But for example, in other contexts, it's held that you can be compelled to give a DNA swab to match your DNA with the DNA on a gun or something of that sort, or give a blood test. Those, even though that type of evidence may incriminate you, it's not protected by the Fifth Amendment. What is clearly protected is you cannot be compelled to give verbal testimony against yourself. And back on computers, particularly in white-collar crime areas, I mean, you can have a business that may be suspected of illegal activity, but it also has a number of employees who are just trying to earn a living. And if you go in there, you government, and take all of their computers out of the business, they can't function at all. So what's frequently done is the government will take the computers for a brief period of time, create a mirror image of everything that's on the computer, and then return the computers to the company or to the defendant so that they can continue functioning as they normally would. But meanwhile, then the government has the ability to look through everything they've made a copy of. Search warrants for computers are very difficult too, because of the volume of information that computers can store. As Trini was saying, I have to be careful that the warrant that I'm going to issue, if I'm going to issue it, is narrowly tailored to the particular crimes that they're investigating, so that they're just not rummaging through everything. Not that you would, don't get me wrong, to find evidence of perhaps other crimes.
As this proceeds through the court system, there are reporters there, not at all stages, but the word leaks out and stuff like that. How do you deal with that? I mean, do you have a press agent? And in the court system, the federal court system, that sort of reacts to the inquiry saying, we understand such and such judge is considering a warrant for such and such. How do you deal with that?
Well, if it's the question, am I considering a warrant for something, the answer is get out of here. I mean, I will not allow anybody to have any information about anything I'm doing until I've done it. And that includes considering a search warrant application, or considering an application for a criminal complaint, or frankly, any type of decision I'm going to make until I've actually signed my name on the line. That's confidential information. So for example, I have law student interns who work with me. I have an intern from UB Law School this semester, and quite often I'll have somebody in the summer. And the first thing I say to them is how important confidentiality is, because they're going to be seeing things that may eventually become public. They may never become public, and so confidentiality is critical. Occasionally we'll get calls from a newspaper or a TV station saying, I understand you're going to have an appearance of so-and-so. Now, we'll give them public information in terms of is an appearance coming up, is a schedule. We'll give them that, but anything that is not public, we don't share. I don't have my own press agent. I wish I did, but I don't. So.
Are you able to walk away at the end of the day and you've done all the legal work you've done and take off the robe, go home? Can you be able to draw a curtain yourself personally?
Well, when I first started, every time I come into a courtroom, everybody stands up, and so I was hoping that when I came home, my wife. I was quickly made to learn that was not in the cards. Yeah, that's interesting, and it's true in the practice of law too. I mean, all of us have difficulty hitting the off switch, and I try to, as I said, some of the things. When I was at Phillips Lytle, I did commercial litigation, which was tough, but seeing things on the criminal side, I realized, and I'll be the first to say, I grew up. Trini talked about different life experiences. I grew up in a very sheltered environment, for which I'm thankful to my parents, but it's a tough world out there in a lot of respects and for a lot of people, and there are some very disturbing things that go on, and it's hard to say that has no impact on me or anybody at the end of the day, but you just do your best to do what you can do, decide what you're going to decide, and then move on to the next thing. I try not to second guess myself, but by the same token, and I'm dealing with it in a particular situation right now, and I can't go into detail about it, but it's a situation in which I had written an opinion in another case a couple years ago, coming out in a certain way, and now somebody's made an argument to me that raises a new wrinkle that hadn't been presented the last time around, but it's on the same issue, and I'm thinking, well, I could say, well, I'm just always going to be consistent, and this is the way I ruled then, so this is the way I'm going to rule now. But I think any judge has an obligation to keep an open mind on what they're doing, and be open to the possibility of reconsidering and going in a different direction on a different case. Justice Jackson, had you told me you were going to, there's a beautiful quote from Justice Jackson, which I have not committed to memory, but I've used it a couple times in my opinions, because he said something to the effect of, just because I was wrong in the other case is no reason to be wrong again. And I think one of the things judges have to have is humility. People talk about the black robe disease, where you become a judge and you think you can make no mistakes. Well, I'm a human being, and I know I've made my share of mistakes and will continue to make mistakes. But I think you got to try to be as humble as you can, and be open to what people are arguing to you on a particular case and be open to maybe going in a different direction if that's what you feel you're called to do.
Speaking of humility,
I didn't really mean it.
No, Mike Purley's here, and he's a partner in Hurwitz and Fine, and I'm reading a quote from Robert Fine here that said that you are extremely well regarded. He also said you bring unique talents to the position, has the experience and breadth of private practice, has the judicial temperament necessary and respect of the bar. He further went on to say the merit selection panel was extremely impressed with you and that you were an outstanding choice. Do you agree? You can report this back to Bob.
Yeah. I love Bob. Just tell Bob I love him. Interestingly, I had applied for this position on 3 different occasions, so a little humility is going to come out. I applied in 1994, and the way the process works, you're narrowed down to 5 finalists. I made the list of 5 finalists. They selected Judge Hugh Scott, who passed away sadly last year. Wonderful man, and I don't fault them at all for making that decision. I applied again in 2000, and they selected Judge Ken Schrader, another wonderful man. It opened up again in 2006, and I said to my wife, you know, I might take another shot at it. And she said, don't. She said, I love you, but you're not going to get it, and I don't want your feelings being hurt. And I said, look, I enjoy what I'm doing. I do. I enjoy my partners. I enjoy the practice of law, but I'd like to be a judge if I could. If I don't get it, that's fine. And I may have just a small chance, but if I don't apply, I have no chance. And what I did on the 3rd time around, I leaned heavily on the pity angle with the district judges and reminded them that I had applied twice before, and please don't do this to me again. So I caught somebody on a good day.
Congratulations. You were the judge. You presided very well as Judge Wilkerson earlier today.
It's easy working with a script, let me say.
And it was a script, of course, presented by your former associate at Phillips Lytle, Scott Soroka. And you made some rulings. Now, I had bunch of litigator type people that were sitting at that table right there, in fact, wanted to object to some of your rulings. Now, as you were ruling there, did you have a sense, just out of a curiosity, you saw what was going on? Mr. D'Angelo, in his artful way, and Scott as Mr. Johnson. Did you have a sense that perhaps some of the rulings that Scott had written may not have been accurate?
Oh, they were totally accurate, I will say, and these guys were great. They were great, really. What I try to do as a judge is let the lawyers not play the game, because it's not a game, but let them try the case the way they want to try the case within the confines of the law. One of the things I found, which was kind of tough a transition for me, is to remember now I'm not an advocate for either side. I'm the judge. As Chief Justice Roberts said during his confirmation, we call balls and strikes, which a lot of people accuse us of doing more than that, but that's what we're supposed to do. But I remember a particular trial. I was sitting there, and I had the exhibit book with me, and it was about a contract, and the one lawyer was asking the witness about a particular provision of the contract, and I'm looking and I'm thinking, come on, ask him about this. Why don't you ask him about this? And then I had to remind myself, that lawyer probably knows this case a lot better than I do, and they probably have a good reason for why they are not going in this direction, and I had to just say, calm down, step back, that's not your job. So, but as far as this trial, all my rulings were absolutely correct. So.
There was no appeal, I don't think.
Right.
Is Elliot Romano still here? Elliot? Yeah. Okay, Elliot, stand up for a second. I just want you to know, you mentioned, Judge McCarthy, that perhaps your highest highlight was the Backdraft case and that settlement, but I suspect the second highlight was giving to Elliot Raimondo the St. Thomas More Award in Buffalo. Elliot received that from Judge McCarthy.
That was back in like 2014 or 2015. We'll just lay that out there.
Yeah.
So,
I hope you still have it, Elliot.
yes, I do.
Become corrupted?
Do not tell the local dioceses that I'm back in Jamestown. I know they're looking for funds.
Yeah. So that, anyways, he reported that not only that his name, he's the namesake for Elliot Ness. His dad had watched one too many episodes of Desilu Productions, and so, as is Scott. Scott, your son is named Elliot, right?
He is.
Oh,
yes.
wow.
Yeah. Do you have anything else to disclose?
I have 3 daughters, none of whom are a lawyer. I think I scared them all off it. So, but I do have a son-in-law who's a lawyer, so we kibitz every now and then.
Speaking of kibitzing, is there, as you're driving down here today, knowing that this probably was going to happen, a little chit-chat, was there a question that you were anticipating that I might ask that I haven't broached?
Maybe just, do I miss you every day as my partner? And the answer is, of course.
That's a leading question, but I know the answer, so I don't want to ask it.
No, I don't have any particular things that I wanted to be asked, although I will say if anybody, because believe it or not, I'm not going back to the courthouse today. So if anybody has any questions that they would like to ask of me, I'm happy to, yes.
I have to ask you. So, when you were working with your mom and helping her with the transcripts, did she ever have any commentary about judges or lawyers? And can you have any memory of that, please?
Well, that could be a planted question because I actually did mention what I'm going to say in the eulogy
No,
that I...
I'm just clairvoyant.
In the eulogy when I spoke at her funeral, and this is a true story, my mom had a tremendous attention to detail and was really professional about her work, and there was a particular passage where, I forget what judge it was years ago, but it was a state judge, never would have happened with a federal judge, but he was kind of hemming and hawing, and my mom said, "Do you think I should," it says and should I take that out or should I leave it in? And I thought, you know, even then I felt called to stand up for judges. So I said, "Mom, take that out." So, but yeah, I really did learn a lot from working with her and just hearing the fascinating back and forth between lawyers and witnesses, and that's, I think, how I got interested. But she, and to this day, every time the one thing she would ask me virtually every time she saw me, and to protect her own profession, she'd say, "Now when you're on the bench, do you speak loudly and clearly?" Because the court reporters always wanted to make sure they could hear what was being said. So, are there any, yes?
Elliot.
My question is this from a local bar perspective. I have 2 cases in federal court right now that I love going to federal court, but they're both with judges from Vermont. So I was wondering, are we getting assigned to the federal bench in Vermont? Because everything needs to be a phone and via video conference.
Yeah, actually, there are a couple judges from Vermont who have volunteered to help our Western District with our caseload. So, and actually, they have, Judge Crawford, I know, has come in on occasion to conduct a trial, but all their pretrial proceedings they'll do remotely from Vermont. But yeah, they've been a tremendous help to us because for some reason, I don't know, maybe it's because we're on the border with Canada, but the Western District of New York, our court, is among the busiest in the nation in terms of caseload. So you're getting good service from the judges in Vermont.
Well, I'm trying to get like plane ticket out to Vermont to try. So they're not
If it comes to trial, they'll probably come in. So, yes.
Judge, what would you say to the public that's faced with a barrage of criticism of our judicial system and its alleged failures in the spirit of Judge Jackson and on the longevity and the strength of our justice system, why should the public have confidence in our system, given your view from the court?
Yeah, that's a very, very good and very tough question, because I think, particularly with the public's perception of the Supreme Court and the confirmation process, and how, there's talk about packing the court, things of that sort. I think the public, the goal is that the public should have the right to believe that the judiciary is, again, to use that analogy, calling balls and strikes and nothing else, that they're applying the law as it's required to be applied. I think that the perceptions and it's gone on both sides in the confirmation hearings for Supreme Court candidates. I think sometimes the questioning is not directly relevant to that person's qualification. Sometimes it is. But all I can do is, and I'm thankfully never going to be in that position where I have to sit before a congressional committee to answer questions about my background, at least I hope not. But all I can do as an individual is to try to decide cases as impartially as I can. One of the favorite things I get to do as a magistrate judge, although for the last 2 years we haven't been able to do it because of COVID, is to swear in new citizens. We pack a courtroom and their families come in, and these folks have learned more about our nation and about how it works than I would say 90% of native-born citizens. And it's always such a beautiful occasion to see them just beaming with pride and their family beaming with pride to take the oath of citizenship. And what I always say to them, and I mean this, one of the reasons I like doing it is it's the only time that half the people in the courtroom aren't mad at me. And what I strive to work toward in my decisions, and I think every judge does, is there are going to be winners and there are going to be losers. And my hope is that for those who don't prevail, they can at least see from the way I've treated them or from my reasoning and my decision that I heard what they said, I understand what they said, I respect what they said, but for the following reasons I disagree with it. And if they don't like what I've said, they can appeal it to the district judge or to the Second Circuit, and quite often they do. And believe it or not, I really, sometimes my law clerk, I think Matt Yusick, who's a wonderful guy, I think he takes it more to heart than I do. I just figure I've done the best I can do. I may be wrong, somebody may tell me I'm wrong, but I've done what I can do, and if somebody disagrees with me, that's their prerogative. And now I did have, early on in my career, I had a gentleman who was representing himself, and he made a motion in writing to have me disqualified. And he said, because I still remember the words verbatim because they really hit home with me, he said, "I'm entitled to a sane judge, and I demand one. McCarthy is not a man of sound mind. Perhaps he should go get some treatment. Maybe he will get better." And believe it or not, I didn't step aside in that case. I wanted to, but I didn't. So you just gotta, comes back to humility or having a thick skin or whatever, but you got to roll with the punches as best you can. Scott, or yes?
I think you just answered part of my question, but I'm reflecting on what Greg asked you a while ago. There are things you leave at work and things you don't bring home.
Right.
But I also know there are some things that you cannot leave at work. They come home with you whether you want to or not. But in some ways, once in a while, something comes home with you that helps build you as to who you are. As a judge, what have you seen that you couldn't leave at work that you feel has really developed you as a judge further in a positive way?
That's a great question. Can I get back to you about 4 o'clock with that? One of the things, as I said before, you know, in my experience, I learned up close and personal that it's a whole different world out there. And when I see the backgrounds that some of the criminal defendants in particular come from, and the hardships that they've endured, whether guilty or not, it just makes me thankful for what I've had, but I hope at the same time to be more empathetic to the hardships that a lot of people in life face. Sometimes I think people are driven to crime because they don't have a meaningful option. That's not a legal excuse, but I see, you know, a lot of drug cases in which people just are dealing because they don't have a lot else that they can do. And again, I want to be careful not to excuse that in any way, but some of the backgrounds that people come from, that's been the way they've been brought up, and I don't approve of it, but in a sense, I understand it, and I think that it just drives home to me that as a society, notwithstanding the great strides we've made over the years, we still have a long, long way to go.
In the last paragraph of Judge Jackson's comments, he mentions measuring justice with mercy. Has that affected what you just said, affected how you judge?
Yeah, I you know, bearing in mind when it comes to sentencing, for example, my sentencing is limited. I can only sentence on a misdemeanor case, which goes up to a year, but a year from anybody's life is still a very meaningful situation. So I try to, when I'm sentencing somebody on a misdemeanor, and I don't envy district judges who are confronted with the prospect of sentencing somebody to 30 years or life or whatever, but I try to, and I get, again, a detailed report from the probation office about the person's entire background, and one of the things I look at is, do they seem to have learned their lesson? Are they truly contrite for what they've done? And I find with a lot of people that the experience of having gone through a criminal prosecution and being charged has truly been a wake-up call for them. And so I think I tend to err on the side of believing the best in people and thinking that hopefully they've learned their lesson. By the same token, the sentence has to reflect that a crime has been committed and the seriousness of it. So it's a tough balance to draw, and I wish I had the wisdom of Solomon, but I'm still working on it.
The last question.
Oh, yes.
It seems from all the talk that an awful lot of people don't quite understand how the judicial system works. And my question is there anything that you can suggest that municipalities can do that can expose the public to how the laws, and in particular, how the judicial system works?
Yeah, that's also a great question. I think civics courses, you know, are very important. When I was in high school, I think I took civics courses, social studies, whatever. I don't think maybe I've had a government course, but I really do wish that more people understood the limited role of the judiciary, because we're not legislators. We're not supposed to be making policy. That's for the legislation. And what really bothers me, and I think bothers a lot of people, is when judges are accused by one side or the other of being activist judges, when they're really just applying the law that somebody else has made, whether they agree with it or not. I mean, Justice Scalia, and some people think he was wonderful, some people think he wasn't, but I think he made a very astute observation. He said the sign of being a good judge is sometimes you go in a direction that you don't want to go, because that's what the law requires. I wish that more members of the public understood the nature of a judge's job and why they do what they do. I think the one sin that's unforgivable for a judge is to decide something because you haven't thought about it. And fortunately, I don't think many judges operate that way, but I think most judges devote a lot of attention and agony to coming out with the right decision. Even after I've decided something, I'll still wonder, did I get it right? But it's out there, so I don't know if that answers your question.
Yeah, I guess maybe part two of that, is there anything that you might advocate that municipalities would then do, like in Coudersport, that say here in Jamestown, something we could do that in lieu of everyone going back to school and taking civics courses, that could expose the people to exactly what you said?
Yeah, that's a good. I mean, places like this are, just a wonderful example. More people should come to places like this.
Tell everyone you know.
Everyone, yes.
Well,
do I get
and sign up for the People's Law School.
Yeah, there you go.
Make sure you enroll.
I mean, one of the things that a lot of us here do is a lot of high schools now have mock trial competitions, and I've judged those, and I know a lot of lawyers here have judged them or acted as faculty coaches, and that's a wonderful way for young people to learn how the judicial system works. And but I don't have the answer as to how to better educate the public, but I really think that people need to have a better understanding of how our judicial system works, and because our republic is not guaranteed by any means. It's a frail structure, and we've got to have the shared belief that the law does control, and sometimes I wonder whether that's in danger, but
Thank you.
One thing that's not endangered is the ability for you to capture an audience. I must tell you, we've done this for like 15 years, and nobody left. Look at this.
well, I saw a couple people going. I'm going to be talking.
Well,
about
Trini was one of them, but good luck. Good luck in reminding. But no, that's unbelievable testament to you that you captured their attention. However, the students I know could care less about going back to class, so this was a welcome respite for them.
For the students, if you like, I'll give you a note that you don't have to. You're excused for the rest of the day.
Exactly.
Yeah, so ordered, Ray.
Thank you very much to Judge McCarthy. Thank you.